All right, welcome to the Chapter 5 video lecture. Chapter 5, so we've talked about the historical general principles of criminal law, constitutional limits. We've talked about actus reus, we've talked about mens rea, concurrence, and causation. Now we're going to talk about affirmative defenses. This week we're going to cover justifications. Next week we're going to cover excuses. Justification defenses are self-defense, defense of others, consent, and the choice of evil. So those are the defenses we're going to work through. Now, again, for a justification defense, the defendant admits to engaging in the action, but they say that their conduct was right. Based on the circumstances, their conduct was the right thing to do. This is an affirmative defense. If this works, it is a perfect defense, meaning the defendant is not liable for the criminal harm. So they provide some evidence. If the jury or the judge accepts it, it is a perfect defense. They are no longer responsible for the criminal act. It can also serve as an imperfect defense, though, which results in the defendant being found less culpable. So they might be found guilty of a lesser offense, or they might receive a lesser punishment for the offense. Imperfect defenses are often used as mitigating circumstances to show that they don't deserve the maximum punishment. They deserve a less harsh punishment because there were some circumstances that maybe justified at least some of the behavior. Okay, so imperfect defense, perfect defense. Okay, the first justification defense is self-defense. Now, three circumstances need to coexist for self-defense to be a possibility. Okay, these all need to exist beforehand. We need to have necessity. That is great. The necessity exists right now, and your conduct is for prevention only. So this is intended to remove like preemptive strikes and retaliation. This is to you engage in this act to protect yourself right now to a currently existing threat. If all of those exist, then we need all four elements of self-defense to also exist. So here, we need the defendant to be the non-aggressor. They didn't start or provoke the attack, so they are responding to a spontaneous, uninitiated attack. Then, the defendant can only use deadly force if they believe it's necessary to repel an imminent deadly attack, an attack that's going to happen right now, necessity. The deadly force is needed right now to save my life or prevent a serious bodily injury to me. This comes in again with proportionality. You cannot respond to non-lethal force with deadly force. It needs to be approximately the same thing. So you need to believe that your life or serious bodily injury is imminent to use deadly force. Excessive force is not acceptable. And then you need a reasonable belief. You need to reasonably believe that you needed to use this force to repel an imminent attack. Okay, so each one of these has to exist under the classic legal self-defense. For a non-aggressor, you can, at least in a lot of states, withdraw from the confrontation, and then if you are continually pursued, you can become the non-aggressor. Even if you started it and you try and leave or withdraw and the person refuses to disengage, you can become the non-aggressor again. Here's an example in your book of this, dealing with a domestic violence case. Now, for the other cases, there's a great example about sneak attack being self-defense, which somebody was in, an inmate had been bullied and coerced to provide multiple favors, and he believed that he would be raped within the next day or two. And he was on kitchen duty, and he poured hot oil on the perpetrator of these actions. A couple of hours after he was told that after he left his shift, the bully was going to finish what they started. And so then he poured oil on him. And the courts say this cannot be self-defense. We're missing elements, right? It's not necessary right now. He was not being attacked at that time. We may have an issue of proportionality. Was this excessive? And it wasn't reasonable to believe the attack was going to happen because the person said, we're going to finish this later. Okay, so all those things add up to him not being able to use self-defense. For reasonable belief, there is a specific case in your book, People v. Goats, which deals with whether or not it was reasonable for him to use deadly force in response to being asked for $5 from a group of 4 young men. He responded by shooting because he'd been robbed before, and a lot of the issue there comes down to this may not have been a reasonable response to being asked to provide $5. It may have been a gross overreaction. So again, this case, though, we don't get a final answer. It was reversed and sent back to the trial courts to reinstate counts from the indictment. So we don't get a final answer here. But it's a really helpful case at evaluating and thinking about, was Goats' behavior reasonable based on the circumstances? Now, assuming we can successfully bring forth our self-defense claim, we're not the aggressor, it's necessary, we used the right amount of force, and it was reasonable to think we needed to do so. We have a couple of other issues to talk about that come next. There are 2 rules about whether or not you need to retreat. And the question here is, if you could retreat or escape and avoid the confrontation, should you do so? And there are 2 different rules. One is the retreat to the wall rule, which is that you couldn't use self-defense unless you showed that you attempted to retreat to the wall. This has kind of always been a minority standard in the United States, but it at one time was, I don't know now, but at one time it was the standard in the United Kingdom, and we inherited our common law from them. This came, and some states had this. Other states, though, had a stand your ground type of rule. If you did not start the fight, you could stand your ground and defend yourself without retreating from a place you have the right to be. So if you were trespassing, you could not use this. But if you were in a spot where you were allowed to be, you didn't start the fight, you were not required to retreat. Now, both of these have the castle exception, which is you do not have to retreat if you were attacked in your home. So even if you had a duty to retreat, if you were in your home, there was an exception for that. So you weren't expected to retreat from your house. For domestic violence, though, there have been a couple of needed exceptions. So under the cohabitant exception, people who live in the same home don't have to retreat. And there have been the acknowledgement of battered women's syndrome as a disorder that develops from long-term abuse that may impact a person's perceptions of force, the necessity, and the amount of force needed. And your book has a case from Kansas in 1988, State v. Stewart, and this is kind of a classic example of how the battered women syndrome came to be. This was the first case, and she killed her husband in his sleep. It documents a long history of really disturbing abuse for a long time. She killed him in his sleep, though, and she was convicted of his murder. And, you know, again, there is a part of the law that does look at, is this fair to hold this person responsible? And so we have seen states amend to include a battered women's syndrome defense for for victims of abuse who maybe lose their ability to make these assessments without they cannot be objective about these assessments because of the amount and duration of abuse. And so that's acknowledged that this is not the same as somebody else. Now, okay, so that's self-defense. This is standard traditional criminal law self-defense. Towards the end of the chapter, we're going to talk a little bit about the stand your ground laws. So don't confuse the stand your ground exception, which is a exception to the retreat rule under classic self-defense, with the stand your ground law. But we'll talk about the stand your ground law in a few minutes. First, we're going to talk about the defense of others. Defense of others is you are allowed to protect yourself and your immediate family to the same degree that you can protect yourself. So you can protect maybe your spouse or your children to the same extent you have the right to protect yourself. And the same statutes apply. Some states have expanded the special relationship and made it more broad, so you can assert self-defense on behalf of anyone who has the right to assert it. Other states have kept it fairly small, but maybe included a close friend or your lover who you're not married to. You could defend that person as well. So most states, though, the trend has been to just make it broad, where we don't assess whether or not there's a special relationship. You are allowed to use self-defense on behalf of another. Now, defense of home and property. So we have this idea, your home is kind of your castle, and you have the right to defend yourself and to kind of defend your castle. But this was originally pretty limited. It was only to like nighttime invasions, and it had to be a kind of a robbery. We still have this, but usually it requires an invasion into your home itself before you can use extreme force. And you cannot use that level of force for your surrounding property. For instance, there's a famous California case where a man suspected 2 teenagers were breaking into his shed, and he set up a spring-loaded gun to shoot anyone who opened the door, and he shot a teen when they came back and severely injured him, and the court said that was an excessive amount of force to defend the property. We do value human life over property, so that is a competing concern here. So again, your book notes, you can't set up an automatic device to shoot whoever trips the switch if you're not home. You can use force, but not deadly force. You can use the amount of non-deadly force you reasonably believe is necessary to prevent someone from taking your stuff. You can also chase someone and take your stuff back. You cannot use deadly force. Human life is more valuable than a piece of property under the criminal law. Okay. Now, Newcastle law. So these are the stand your ground laws, they're often called. These are the laws that you don't have to retreat in that you have the right to use, it's an expansion of the ability to use deadly force in your own self-defense, and it removes the requirement to retreat. So we have about 40 states that have some variation of this Newcastle or stand your ground law. And these started being passed, I think, in about 2004, and they've continued to be passed since then. There is some critique by even law enforcement and police chiefs that these give private citizens more right to use force than they give to law enforcement, as well as some people say these are essentially in practice kind of a license to kill somebody. That said, they do exist in most states, in about 40 states. And your book has a chart on page 189, table 5.1, that provides an example of some cases. Most of the people were not charged or not convicted. There have been a couple convictions of people who took their right to defend themselves too far. For example, a retired teacher on a hike fatally shot somebody, claiming that the person charged him, and he was sentenced to 10 years in prison. And then we saw the statute adjusted so that he under the new law, maybe he would not have been convicted. So it's kind of the type of situation that these statutes are designed to protect. Now, moving on to our next defense, a choice of evils defense. So this is kind of completely different. Self-defense, defense of others, defense of home and property, and these stand your ground Newcastle laws are all very similar. This is a different type of justification. Choice of evils is sometimes it's called the general defense of necessity. And this is that you say, I did the action, but I was justified by committing this crime because doing so, by choosing to commit this lesser crime, I avoided the bigger harm of a greater, more serious crime. The most famous case comes from England, the Queen versus Dudley and Stevens in 1984. The two adults, and a 17-year-old without any family responsibilities, were lost on a lifeboat at sea. They had no food or water. And after 20 days, the last 8 without any food, they tried to cast lots to decide who would die and become the food. One person refused. They said a prayer and they killed one. They survived for 4 more days and they were rescued. And they pled this kind of choice of evils. They were sentenced to death, though that wasn't successful, and it wasn't successful. But that's the most the most classic example. Under the Model Penal Code, the defendant has an obligation to identify their 2 evils, rank their 2 evils, and that the evils happen right now. And it identifies some right choices for us. It tells us that it is okay to destroy property to prevent a spreading fire. It's okay to violate a speed limit to get a dying person to the hospital. It's okay to throw cargo overboard to save a sinking ship. In a true emergency, it's okay to dispense a drug without a prescription. It's okay to break and enter a cabin to avoid freezing to death. So those are right choices that can be made under this defense. Your book has an example of drunk driving, a lesser evil than a car going completely out of control. A defendant, underage people were drinking, the most sober was driving, saw a police officer and he jumped into the back. The person who was in the front seat, who was intoxicated, got behind the wheel to stop the car before it ran into somebody or a home or caused more serious harm. He was charged with drunk driving. He He claimed this defense. He said that, drunk driving was the lesser evil than someone dying or someone being seriously injured. We don't find the exact answer. They sent it back for a new trial, but they say he can assert this defense here. Now, the last justification defense is the defense of consent. This is the idea that competent adults can voluntarily consent to crimes against themselves if they understand what they're consenting to. The most common context for this is, so you can consent to take your own life. You can also consent to have an injury inflicted on yourself. But the most common example of this is engaging in a sporting event, like a pickup game. By engaging the game, you consent that you could experience an injury. Voluntary consent is that you are not forced or coerced into consenting. Knowing consent is that you understand the risks and that you are old enough and have the mental capacity to consent. And authorized consent is that you are someone who is capable of giving this consent. You're legally responsible. And then there's an example in your book about a basketball game. But there are also other examples about assaults and things. So that is the last defense. Again, it's usually used for like sporting events. All right, we covered a lot of ground here. Self-defense is a really important concept. You do need to understand the traditional self-defense as well as how self-defense has been altered under these new case law laws and or stand your ground laws. So that's very important to understand. If you have any questions about anything, please reach out. I look forward to working with you. Have a great week.